Hi, this is a training video commissioned by the Immigration Advice Authority on the subject of settlement in the UK. My name's David James. I'm a practicing barrister special in immigration law, working out of Garden Court Chambers, and a director of HJT Training, who have been commissioned to prepare these training videos with the IAA. This video has been designed to cover all levels of work. Watching this video, however, does not qualify you in any way to work above the level you're registered in. If you do wish to work at a higher level, you must go through the raising level procedure and not undertake any work at a higher level until you're formally registered to do so. Okay, so let's get started. Settlement in the UK. So first of all, just a course overview. So this training guide equips IAA advisors with hopefully a thorough, up-to-date understanding of the settlement arrangements as of March 2026. And anyone working in the area of immigration law knows how fast-moving it can be. So it'll be very important, as I'll stress at various points in the training, that don't rely on this video prospectively as authoritative on every area, on every issue and area with regard to settlement, but acquaint yourself with whatever the current procedures, practices, rules are at the point at which you're offering advice or preparing applications. So the framework for the training, there are 4 different elements to it. First, we're going to look at the legal foundations of indefinite leave to remain and the facets of that status. We're going to then look at the rights and routes, so the current routes to settlement, qualifying periods, and the rights that settlement confers. We're going to look at how settlement operates with regard to those who are present in the UK as dependents of persons with immigration status in a variety of different categories. And then we're going to look at the earned settlement arrangements, which are the proposed arrangements for reform of settlement routes, some of which have been implemented already, others of which are still being appraised, and looks like implementation will occur later this year, although the precise form of those changes is yet to be finalised. So, legal definition of settlement, first of all. And we look to, as is often the case with fundamental rights with regard to immigration status and fundamental powers, we look to the Immigration Act 1971. And under Section 3.1 of the 1971 Act, the Secretary of State was granted the power to extend limited leave or indefinite leave to remain, or enter or remain, as the case may be. And there is a specific definition of settlement under the Act, Section 33, subsection 2A, which was introduced by the British Nationality Act. And settlement is defined in that provision as being ordinarily resident in the UK without being subject to any restriction on the period of stay. And then there's also reference at Section 8.5 of the Act to exempt persons, just to distinguish an exempt person such as a diplomat is not, that status is not the same as a settled person. So exemption from immigration control is not the same as settlement. All right, 2 distinct forms of settlement, or rather, if you like, 2 different routes, principal routes to settlement, one under immigration procedures, the other under the EUSS settlement scheme. The ILR route, as opposed to the EUSS settled status route, is the more traditional form of settlement. The principal differences between the 2 routes we're going to look at in a moment, but it's just important to bear in mind that there are, if you like, these 2 distinct categories leading to the same form of status, but the journey there is variable. What are the principal variations between those 2 routes? Well, first of all, with regard to ILR, persons who go through the immigration route, the principal distinction is that a 2-year continuous absence from the United Kingdom can lead that status to expire. Whereas, contrastingly, for those who acquire settlement through the EUSS route, it would require a 5-year continuous period of absence before that leave would be susceptible to expiration. Just to stress that the continuous absence is not an automatic barrier to the retention of ILR. It is feasible to demonstrate through evidence good reasons for that absence, in which case the expiration of that status may not be affected. The other principal difference between the EUSS route and the typical ILR route for immigration categories is that different suitability considerations apply. And so with regard to EUSS route, the evaluation of character and conduct is performed against the old good character elements that operated under the EU regulations before the UK left the EU. And that is a threshold principally of determining whether a person presently represents a genuine, present and sufficiently serious threat so as to necessitate their exclusion. Whereas for immigration routes, there are now standard suitability criteria, either through part suitability or through specific suitability provisions within particular categories, such as Appendix FM. The other principal distinction between the routes going forward is that the EUSS settled status route is not going to be affected in any way, it seems, by the earned settlement proposals that have been introduced and are being introduced incrementally at the moment, but we'll return to those a little later. So, look at the three-part assessment framework for qualification for settlement. And so the three elements, we've got a little jigsaw illustration there, and if you follow it around anti-clockwise, the first thing to establish settlement is to make a valid application. The second is to satisfy the eligibility criteria together with the suitability criteria, which will ultimately, if you navigate those three areas, will lead you to the outcome of a grant of settled status. So we're going to look at those three areas in turn: validity, eligibility, and suitability. And first, looking at validity, quite straightforwardly, you must have an application for settlement, pay the correct fee. You can see here highlighted on the right-hand side of the screen that the current fee as of March 2026, the standard fee for ILR routes is about £3,029, although there are variations for settlement routes. So you need to interrogate the fee structures applicable to the particular category you're applying under. Some categories, such as protection settlement, have no fees attached whatsoever. So you have to pay the correct fee. There is no IHS surcharge for settlement applications. You obviously must apply in the correct form, and the prescribed forms are detailed online, and you should be able to navigate fairly straightforwardly by reference to the background to the most recent status that the individual possesses as to what is the appropriate form to apply on for settlement. You need to present with that valid application and that fee paid relevant travel documents and biometric documents. And finally, the correct immigration permissions must also be retained, referable to the particular category under which you're making the settlement application. The importance of making a valid application we'll see even more clearly in due course when we look at Section 3C of the 1971 Act again. It's only in the presence of a valid application that a person's lawful residence will persist after the expiration of any limited leave whilst they're awaiting the outcome of any settlement application. So it's imperative that the application is made validly. So then looking at the eligibility criteria, obviously these are going to vary by reference to the individual's immigration status from which on which settled status is being fixed. So if you look at the third point, really starting with that, it's the route-specific criteria will have to be interrogated for each individual application. But there are certain consistent criteria that apply for all applications for settlement. The first relates to continuous residence. There are some nominal variations in the duration of absences which are tolerated, particularly with regard to those applying on long residence arrangements, 10-year lawful residence. We'll come to that a little bit later. But typically, the position is that in order to be eligible for settlement, one has to demonstrate residence lawfully for at least 5 years, typically. Some variations we'll touch upon later, and absences of no more than 180 days in any 12-month period assessed on a rolling basis. So 180 days is the outer limit typically, although there are some exceptions permitted, which again we'll return to in due course. In addition to that continuous residence requirement, there is a standard requirement for most categories that one satisfies both the knowledge of life in the UK test, have to complete that test, and meets the language requirements. Now, this dealing with the language requirements, first of all, the standard presently, indeed until the 26th of March 2027, is the CEFR level B1 standard. But from March 2027, it's going to be elevated to B2, which is a significant change. And the object behind that is to encourage and enable integration. In addition to the language requirements, there is also the requirement to pass the life in the UK test. It's a 24-question multiple choice assessment, and those taking it have to pass with over 75%. A little bit more detail about life in the UK, the life in the UK test and the English language requirements. There are certain categories of person who are accepted from both. With regard to the English language requirements, if you are from a majority English-speaking country, you may be accepted, and the countries accepted are specified within the immigration rules. If you have obviously passed the requisite test, then you'll satisfy the requirements of the language requirement, but it depends. As we've seen, you need to scrutinize what the language requirements are at the time that you're making the application to make sure that there's no variation. Presently B1, next March, B2. The alternative is to either of those courses is to have acquired a degree which is taught or researched in English. With regard to the Life in the UK test, we've outlined already what the general provisions are for the background to the test and the threshold that you have to attain in order to pass the test. But there are certain categories of people who are exempted from having to complete that test. And that includes persons who are under the age of 18 or over the age of 65, who have a physical or mental condition, which makes it unreasonable for them to be required to meet that threshold test. Bereaved partners, victims of domestic abuse, and adult dependent relatives are all accepted. And then there are other certain specified categories who are also excluded. And again, you'll need to interrogate the immigration rules at the relevant time to ascertain whether or not there is a particular criteria that may cause your client to be excluded. Turning then to suitability, and this is an absolute barrier. If one doesn't meet the suitability requirements, then regardless of whether the eligibility elements of the test are met, and regardless of whether you've made a valid application, you're going to be denied settlement. There are some aspects of conduct which lead to mandatory refusal. There are others which inform only the facility to deny settlement, don't obligate the denial of settlement. As far as mandatory grounds for refusal are concerned, they're described on the left-hand side in the yellow box. So if an applicant is subject to a deportation or exclusion order, then that is a mandatory basis for refusal of settlement. If it's deemed that there is a public good considerations with regard to character, conduct, or associations, then that may be a mandatory basis for exclusion. But a custodial sentence of 12 months or more, persistent offending or offending deemed to cause serious harm, that will mandate refusal also. And indeed, in respect of those who have custodial sentences of 12 months, that can constitute a permanent barrier to settled status. On the other side of the equation, there is the facility invested in the Secretary of State and her officers to deny settlement on a discretionary basis, even when the threshold, for example, of a 12-month custodial sentence is not met. And so non-custodial sentences can lead to be a barrier to settlement, as can breach of the immigration laws, including overstaying or breach of conditions or deception in the acquisition of immigration status, falling into the same ambit, false representations, production of false documents. and also the failure to pay an NHS charge. So indeed, litigation charges, so if in addition to NHS charges, can also be a barrier on suitability grounds. And so if, for example, a person's been involved in litigation with the Secretary of State in connection with a previous refusal of leave, which was unsuccessful, but their status was nonetheless restored at some point, a failure to pay any debt to the government could also be a barrier. So the kinds of exercises that you're going to need to perform as a practitioner is sort of a fairly far-ranging interrogation of those sorts of considerations in order to ensure that there aren't any sort of potential barriers to accessing settlement. So don't focus solely on eligibility. Think carefully and expansively about suitability issues. And the best way to do that is to work through the suitability criteria applicable to the individual application for settlement and put questions to your client to ensure that there's no compromise within those criteria on the particular facts of your case. And if there are, then furnish an explanation to the extent that there are discretionary grounds as to why, in the particular circumstance of your client's case, those considerations should not operate as a barrier to settled status. So when is continuous residence broken? So just returning to that continuous residence issue we looked at earlier, the maximum level of absences which are permitted and the necessity for lawful residence over a 5-year period, acts such as convictions or imprisonment, the imposition of a deportation or removal order, periods of overstaying, exceeding the maximum absences, all of those factors can actually operate as a break in lawful residence, which have the effect then of compromising the facility to make an application for settlement. Just on the point of overstaying, a point of emphasis, there is a little give afforded with regard to overstaying where a person's lawful leave lapses, but within the 14-day period, they make a further application, valid application, which is deemed eligible and leave is extended. That level of absence won't ordinarily operate as a barrier. And indeed, historically, that period is extended to 28 days, although that's of very little relevance now, save for those who may be still applying until November 2026 in the long residence 10-year category. There might still be a necessity to refer to the 28-day break, but that only operates in respect of individuals who had a break prior to 24th of November 2016 of up to 28 days. So why go for settlement? What are the advantages that come with settled status? Well, they're significant. The principal advantage is that which we identified when we looked at the definition of settled status in the 1971 Act. It is that you are effectively free of immigration control. And indeed, as we'll see, there are only very limited circumstances in which a settled person can be deprived of that status. So they can be deprived of it if they exceed the level of time permitted outside the United Kingdom, 2 years for a person under the immigration arrangements, 5 years for an EUSS settled person. It can be deprived of settled status too in circumstances where it's subsequently determined that they acquired that status by deception, or they can be deprived of that status if they engage in serious criminal activity, which can lead to the imposition of a deportation order. But other than those three sets of circumstances, there are no other basis upon which a person can be again subject to general immigration arrangements. So ILR frees you from the obligation to be constantly renewing status, paying application fees, paying IHS surcharges. It gives you the facility to travel without inhibition and without significant scrutiny. In addition to that liberation with regard to immigration status, it has other significant consequences. Persons with settled status are free to access public funds if they need them. So the no recourse to public funds provisions don't apply to those with settled status. They have unrestricted access to employment. So skilled workers, for example, who shift from that status into settled status are no longer confined to working for a particular employer or obligated to make a formal application to change employers into another place of employment where the employer is again capable of sponsoring them. So it's a liberation in terms of the forms of employment that you can engage in. It's a pathway to citizenship. Within 12 months of acquiring settled status, presuming there are no significant absences in that 12-month period, and you're present at the time that you make the application after 12 months, it should be a relatively straightforward process to acquire British nationality. Obviously, good character is a consideration in British nationality assessments, and the character requirements are more stringent than those that operate under the immigration rules with regard to settlement. But typically, if you meet the suitability criteria for settlement 12 months prior to your naturalisation application, and nothing has happened in that intervening 12 months, you should not encounter any significant obstacles to acquiring British citizenship. So a significant opportunity created by the acquisition of settled status. Other additional entitlements that come with settled status, which are significant with regard to education and finance. A person who's here as a settled person, effectively, who wants to study, is then treated as a domestic student, and so not subject to foreign student fees, and also is able to access student finance. Persons with ILR are able to sponsor in family members under provisions such as Appendix FM or under the adult dependent relative categories, for example, within Appendix FM, so partners, children, adult dependent relatives. Commonwealth citizens with ILR have the facility to vote. Other foreign nationals have to naturalise before they acquire that right, but it's, as I mentioned before, should be a relatively straightforward exercise from ILR to naturalisation if that's indeed what people want to do. So the right to vote comes either automatically with ILR for Commonwealth citizens or within short order for those with ILR who then naturalise. And then for children where their parents have acquired settled status, a child born in this country where the parent acquires settled status will automatically become British. And other children have the facility to register as British once their parents acquire settled status. So we're going to look now at the different routes to settlement by category. Obviously, this is not a complete guide. And again, as I stressed at the beginning, this is the position as it is at March 2026. And so it's going to be important, regardless of what is described in this PowerPoint and in this presentation, when you're making an application, to carefully scrutinise the rules applicable to the individual category of applicant that you're concerned with. So that's just a general overview of the provisions relating to settlement, the timeframes that generally operate. Presently, for most immigration categories, it is possible for those who are lawfully present, particularly those who acquired the right to reside here first through an application for entry clearance. The typical period that one has to establish in order to be eligible for ILR is 5 years of lawful residence. So you have on the right-hand side the routes described, skilled workers and healthcare workers, for example, some variation in that category, as we'll see, with regard to the earned settlement routes. But global talent, UK ancestry, scaling up, partners under Appendix FM, refugees, British overseas citizens, all of those categories, a 5-year qualifying period of lawful residence, making a person eligible to apply for ILR. Within those categories, as we'll see, there are certain persons who have the opportunity to accelerate their access to settlement. And that's typically dictated either by the level of earnings, if you're in a managed migration category, or by the particular attributes that an individual possesses. If they're a particularly capable individual within the global talent route, for example, they may be able to accelerate to settlement within 3 years, just as an illustration. And then there are other categories who typically on a compassionate basis will be able to settle immediately. You'll see at the bottom of the list, the current periods, immediate for bereaved partners, domestic abuse victims. That's domestic abuse within the context of admission under Appendix FM as a partner, and under the adult dependent relative arrangements for, again, persons who have acquired a right to enter under Appendix FM. Immediate right to settlement for those categories because of the particular compelling and compassionate nature of their circumstances. We're going to look at a few of particular and look in a little bit more detail at the individualized settlement arrangements for those routes. And first, we're going to look at skilled workers, and within skilled workers, then the subcategory of health and care workers. And so for skilled workers, first of all, as I mentioned, it's typically a 5-year continuous residence requirement, with the requirement to demonstrate at the point of the settlement application the enjoyment of a general salary in excess of £38,700, or whatever the going rate is for the category employment that the person has been admitted in, because it may be higher for certain categories. And we're going to look, as we go through these routes, at what is coming in terms of the earned settlement proposals. And just to stress, for skilled workers, these arrangements were not in place at the time that this presentation was prepared in March 2026. But the proposal, which is a broad-ranging proposal, is that skilled workers prospectively will be required to demonstrate 10 years continuous lawful residence before they're eligible, subject to a person being in receipt of very high income, by reference to which they can reduce the time for the establishment of that entitlement. So the expectation is that for those earning in excess of £50,270 over a 3-year period up to the point of the settlement application, they will still be able to apply for settlement after 5 years. And for those earning for that period of time, that 3-year period, over £125,140, they may be able to get settlement within 3 years. Switching over to the subcategory of health and care workers, quite a different approach taken with regard to that category of person. And you can see there the disparity between the two positions is essentially, depending on skill level and income level, the route to settlement and to vary going forward under the skilled worker route. And so for health and care workers, the current arrangements are settlement after 5 years and demonstration of the requisite salary thresholds, and they will vary depending on the sector in which of health and care work that you're engaged in. The earned settlement proposals are looking to extend that settlement route from 5 years to 15 years as a baseline, and that 15 years applying to all those who are in roles at or below RQF level 6. Turning then to talent and business, global talent and innovator founder routes, there is an accelerated route to settlement for global talent, where a person presents as exceptionally talented, and that's endorsed by an approved body. They may be able to acquire settlement within 3 years, or in the alternative, a person is describable as exceptionally promising, again, as endorsed by an approved body, a 5-year route to settlement, as opposed to the 10-year route that is intended generally under the earned settlement provisions. That 5 years may be retained if you are an exceptionally promising individual under the global talent route. For innovator founder, the 3-year route to settlement there is a 3-year route to settlement which is subject to an endorsement letter confirming significant business achievements and the satisfaction of at least 2 of 7 specified criteria, which again relate to income levels and job creation and things of that nature. And then finally, just the kind of hangover from the preceding category, that of tier one investors, where there was a specific arrangement whereby those investing over 10 million were able to acquire settlement within 2 years, and those investing over 5 million, I think, also able to accelerate settlement within 3 years. Those provisions generally lapsed. That route was closed in 2022, but there may still be a hangover. There may still be people here potentially who are able to right to settlement based on that preceding statement, and there are particular arrangements that operate. Unlikely now in 2026, 4 years on from the closure of that route, but worth flagging up just as a point of interest more than anything else. So under family routes, partner route typically under Appendix FM is a 5-year route to settlement. The requirement for the minimum income threshold persists through to the settle stage. You have to demonstrate again income at the level specified in the rules at the requisite time, which is variable. For those who don't meet, this is the partner route 10 years, the next box along. For those that don't meet or didn't meet all the requirements of Appendix FM but were admitted exceptionally, it's a 10-year pathway to settlement. It is possible to switch out of the 10-year route and into the 5-year route, but again, that will necessitate satisfaction of all of the requirements in the Appendix FM and no reliance on exceptionality. For parent routes, that's the third box along. Settlement is typically after 5 years, so that's a parent of a child who is British or settled in the UK. If the child has one of those forms of status, nationality or status, then typically it's a 5-year path to settlement. It can be extended to 10 years in certain instances where the requirements of the rules under Appendix FM are not met, and admission or leave to remain is extended to the parent, exceptionally under an Article 8 unjustifiably harsh assessment. Adult dependent relatives, next box down at the bottom, we've looked at already, saw in that table, immediate settlement, unless the sponsor is a person whose status is not settled. And so again, if a person who is sponsoring is essentially doing so on an exceptional basis that doesn't fit within the ADR provisions, then if their dependent relative is admitted, they'll be subject to an extended time frame for settlement. And then finally, bereaved partners and domestic abuse sufferers. This is people who have been admitted under Appendix FM and who suffer the tragedies either of losing their settled or British partner during the currency of their lawful residence as a partner, or regrettably and tragically are subjected to domestic violence and have demonstrated the requirements of the DVLR appendix so as to establish their victimhood. Those persons, once recognised, will be entitled to settled status immediately on recognition of their circumstances. There are the typical fees applicable for application of those categories, but they can be waived based on the circumstances of the individual, and applications for fee waivers can be made for those who are destitute. And we're going to look at the long residence and private life routes and the protection routes, what the residence and the settlement requirements are for those categories of person. With regard to long residence, this is the 10 years continuous residence route. It's actually proposed to be phased out under the earned settlement arrangements. But presently, on that route, the significant maximum absence permitted over that 10 years of 540 days, and no more than 184 days of absence in any one 12-month period. I think we'll see in a moment, a little bit later, that 184 days actually varies back to 180 days, I think, after 2024. That route, as I mentioned, is up for abolition under the earned settlement framework. So far as private life is concerned, their typical route for those who establish a right to remain here on private life grounds under the immigration rules, it's a 10-year route to settlement, but that period can be reduced for young people who establish that private life right to reside based on residence for more than half their life in the UK, and 5 years lawful residence may enable access to settlement for that category of applicant. Turning to refugee leave and humanitarian protection, the general period of leave extended to persons who are recognised to be refugees or to have an entitlement to humanitarian protection is a grant, or was a grant, of 5 years lawful residence. At the conclusion of that 5 year period, it was a pretty straightforward step into settled status, subject to a suitability appraisal and an active review of whether there was a persisting protection need. But it was a relatively unproblematic exercise. That has been changed now, albeit not for people who enjoyed that status prior to the 2nd of March 2026, but for those who acquire protection leave on the protection route or humanitarian protection post the 2nd of March 2026, those individuals now have an expectation of only 30 months leave on recognition, and will be subject to at least one review after that 30 months, before, assuming their leave is extended, before they're then entitled to apply for settlement. And the proposal is, although it's not implemented yet, that the time frame will be extended from 5 years lawful residence, after which an application for settlement can be made, potentially up to 20 years as a baseline for refugees and those with humanitarian protection, with a subcategory of people who are resettled here in those routes, in respect of whom a 10-year baseline will operate. And there are ways in which that significant threshold, if it's introduced, can be reduced, but it is a significant deviation if indeed that is the route that is taken in due course by the government. Outside of humanitarian protection and refugee leave, for those who acquire a right to reside on the basis of discretion leave on compelling compassionate basis, again, it's a 10-year route to settlement typically. And then there are subcategories for Hong Kong BNOs, for example. It's a 5-year route to settlement. Many of those persons who acquired a right to reside will be eligible for settlement this year. The route introduced in 2021 and accessed extensively, so that the expectation is that up to 92,000 settlement grants could be made this year. And the access to settlement is subject to obviously suitability requirements and to language requirements. There's also a minimum income requirement, but it's fairly modest by comparison to that which is implemented with regard to Appendix FM, for instance. The minimum income for Hong Kong BNOs visas is £12,570. Apart from the BNO route, there were 2 separate specific routes for Afghan nationals who had worked with the UK during the time preceding the resumption of control of Afghanistan by the Taliban. And under those routes, the Afghan Arab route and the Afghan ACRS route, there were certain persons who acquired a right to settle immediately under recognition within those routes. Other persons acquired a right to settle following 5 years lawful residence in those categories. Both of those categories were closed last year, July last year, although there is some controversy in the courts at the moment about whether those routes should be extended. So you will need to, again, scrutinise the rules and any transitional arrangements and any judicial authority in order to ascertain whether some benefit could still be obtained by an Afghan national by reference to those 2 categories of application. For HM Armed Forces, so for foreign and Commonwealth citizens who work or engaged within the armed services for up to 4 years, there is a route to settlement after 4 years or earlier if they're discharged from service on medical basis due to service-related injury. Significantly, with regard to that category of person, it's possible to make an application for settlement up to 18 months before discharge and within 2 years of discharge. So the entitlement to apply for settlement persists for a further 2 years after they're discharged from service. And then there's a subcategory of arrangements for Gurkhas, which will need to be looked at separately if you're dealing with an applicant who falls into that category. And then there are certain categories of status which never lead to settlement. And that includes those who are present under the Ukrainian scheme, for those who are senior or specialist workers, or for overseas domestic workers. It may be possible for persons in those categories to switch out of those categories into a different immigration category that may lead to settlement. And that might be something that you'd want to explore if you're approached by an applicant who is currently enjoying status under one of those routes and is looking to establish a more permanent right to reside in the UK. So we're going to turn now to dependents and dependents qualification for settlement. So these are persons whose status is fixed upon the presence of a person in a skilled worker category, for example. They've been admitted either as a partner or as a child of a person in another immigration category. So how do they qualify for settlement? Typically, they qualify in line with the principal. So partners on the dependent route will typically qualify after 5 years continuous residence. But if the principal obtains access to settlement on an accelerated basis, so if they are able to take advantage because under the global talent route, for example, of settlement within 3 years, that doesn't automatically extend that facility to their dependents. For child dependents, they usually can apply for settlement at the same time as their parent or parents are applying. Assuming there's only one parent, then the child can apply at the same time, even if they haven't acquired 5 years lawful residence. For children who have attained the age of 18, before they're eligible to apply for settlement, they'll have to make a separate application. They can't apply on the same settlement application form as their parents, but children under 18 can do so. And notably, child dependents are not subject to the 180-day absent limitation. And then finally, just with regard to the timing of applications, it is typically, with the exception of certain categories, such as those who've worked in the armed forces, it's typically feasible to make an application for settlement 28 days prior to the expiration of your current leave and prior to the accumulation of 5 years lawful residence. Certain other categories, it's possible to make that application up to 3 months earlier. So you need, again, to look at the immigration rules and see what is the cut-off point at which applications can be made prior to the acquisition of 5 years lawful residence. Is there a particular arrangement that offers a settlement application? So just to be aware, for these dependent categories, if a person is here as the partner of a British citizen or a settled person and the relationship breaks down, so they're admitted under Appendix FM, then the likelihood is that their leave is going to be cancelled or curtailed. But they will have an opportunity to switch into a different category, and typically a grace period of 60 days is granted from the point at which the person is informed that their leave is not going to persist. And indeed, that grace period is extended for anyone who's subject to curtailment or cancellation arrangements. And just under the earned settlement proposals, the arrangements going forward for dependents, the provisions which are not yet in force are intended to have a variety of different effects, including the introduction of a minimum earning threshold for dependents of £12,570, although there's concern about the implementation of that because it will be applied for an extended period of at least 3 years of the dependent's lawful residence, and it will impact on those who are present here often as the carers for the child of the principal migrant. And so it's a fairly prejudicial consequence, which is the effect of which is being interrogated at the moment to see whether or not it's appropriate to implement it at that level. We've also seen that there is a hiking up or an elevation of other requirements, such as the English language requirement and the character requirements. And just very quickly, we're going to look at the earned settlement framework, but obviously you're going to need to interrogate this more carefully yourself once it's fully implemented. And so just a brief outline, first of all, of the progress toward the earned settlement arrangements. And the critical reference on this slide is to the implementation expectation date, which is autumn 2026. So at that point, when you're dealing with applications post-autumn 2026, August, September, you need to interrogate the immigration rules very carefully to make sure you understand what the settlement arrangements are at that moment. And the 4 pillars of the earned settlement arrangements we've looked at already relates to character, focusing on integration, looking for a contribution so that people are their presence is economically beneficial, and reducing flexibility with regard to periods of absences, again, with a focus on that integration. And there are certain baseline criteria now we've looked at already briefly. The elevation of the settlement periods required in many categories up to 10 years and some categories up to 20 years, but reductions possible based on income levels and employment in particular sectors and person presenting with particular levels of talent, but also reductions potentially on the basis of community volunteering or acquisitions of higher level of English language up to C1. Then the provisions relating to implementation, the earned settlement routes which have already been implemented, just outlining those which we've touched on already with regard to refugees. There's also a forced break, which isn't specifically applicable to this settlement consideration today, but just under the C1691 provisions, a barrier to actual applications, for example, for students from Afghanistan. One of the controversies which is yet to be resolved is what the transitional arrangements will be for those who are already lawfully present at the time when the earned settlement arrangements come into play. The government's standing position is everyone will be affected by this change, although it makes an exception for protection categories, those that had that status prior to the 2nd of March 2026. There is still controversy about this, and so you'll need to, as I say, review what the rules are and the transitional arrangements, if any, are when the earned settlement arrangements are implemented in due course. But there is likely to be some challenge if there are no transitional arrangements based on the expectations of people generated from the rules that were applicable at the time when they first came into the UK before the settlement provisions were altered. And then finally, just looking at accelerated pathways that may survive the new earned settlement arrangements, just an outline of those categories here. Global talent, innovator, high earners, and BNOs and British citizen partners. There's no expectation that their access to settlement will be altered. But again, you're going to need to evaluate the category that's applicable in order to discern what ultimately the arrangements are at the time you're making your application. And finally, what disrupts or breaks path to settlement? We've already looked at absences, extensive absences, overstaying, and criminal convictions, suitability. They can bar access to settlement. So just an overview there for your benefit. And then we've looked at the breaks in residence outside of the UK that can operate so as to cause to fall into controversy the persistence of settled status and the timeframes that operate. Returning residence route, you'll see, as I mentioned earlier, that it's not an automatic barrier to retention of ILR, but you're going to need to demonstrate the persistence of ties in order to retain that status if you have extensive absences of more than 2 years for those with ILR or more than 5 years for those with EUSS settled status. And finally, Section 3C, which I mentioned earlier, this provision which extends lawful residence once a valid application is made. All of the time spent on Section 3C leave under the 1971 Act counts as lawful residence and is lawful residence in the category that you possessed at the time when you were making your extension application. and so will count towards the acquisition of settled status either within that specific category or under the long residence 10-year provision for however long that status persists. And within that final evaluation, touching again on the curtailment and cancellation of leave arrangements, and just a description here of the typical consequences of conduct which may lead to curtailment or cancellation. So a failure to meet the eligibility criteria at the point that a settlement application is made would prevent acquisition of settlement. But the retention of lawful continuous residence in order to enable an application for settlement can be interrupted if it's identified that there is conduct or including breaches of immigration conditions, which means that the Home Office can take away that status, preventing the accumulation of 5 years lawful residence. But typically, as I mentioned before, a grace period will be given unless there are significant breaches, and a person may be able to shift into an alternate category. So I think that concludes the review of settlement arrangements. And I think the only remaining observations to make are really those to reiterate what we said at the beginning of the presentation, that this is not, this training video is not a route to your elevation with regard to your accreditation. You can't do different forms of work above the level that you're accredited at as a consequence of engaging with this presentation, but we do hope that you found it useful, and it may operate as a mechanism to enable you to take the requisite tests to acquire a high level of accreditation. And I wish you luck with that if that is what you elect to do. There is a formal process to level up, which you're doubtless familiar with, but you can obtain information about that from the IAA website. So without further ado, thank you for watching and goodbye.